Hi everyone, today we will do legal dictation exercise number 61. You can get the PDF from description box. So ready? Start. On an examination of the pleading of two writ petition, we find that the issue for consideration were all different in the petition. In the first petition, relief was sought under the Contract Labour Act 1970 for abolition of contract labor system in the operation of canteen in the marketing establishment of IOC and for observing the canteen worker as employees of IOC. In the second petition, relief was sought under the Industrial Dispute Act 1947 for making a reference under Section 10(1) to the Industrial Tribunal to decide whether the contract between IOC and the canteen contractor was sham, nominal, and a mere camouflage to avoid extension of labor law benefit to the worker in question, and whether the canteen workers were the direct employees of IOC. The assumption that the appellant had taken inconsistent stand in the two writ petition is not correct. Even in the first writ petition, the appellant had contended that though the contractor changed from time to time, the worker in the canteen remained the same with continuity of service, that IOC had mollified and illegally kept the worker as contract labor in order to keep them in a permanent state of insecurity and to deny them the wage and privilege available to permanent worker, that IOC was actually controlling and supervising the canteen, and that only as camouflage the contractor was shown as running the canteen to create a pretense that the workmen of IOC were the worker of contractor, when in fact they were employees of IOC. In short, the appellant had contended that the contract was sham and nominal in the first petition, when in the second writ petition the contention was that the contract was sham and camouflage to avoid extending benefit of regular employees to the canteen worker. Therefore, the High Court committed a serious error in assuming that in the first writ petition the appellant had conceded that the contract between the IOC and canteen contractor was valid and genuine, and that in the second writ petition the appellant had taken a contrary stand, that the contract was sham and a camouflage. The stand of the appellant and the worker was always consistent, but before the decision of a constituent bench of this court in Steel Authority of India Limited versus National Union Waterfront Worker 2001 SCC 1, it was thought that the appropriate relief available was to seek an investigation and abolition of contract labor and consequently seek absorption. Therefore, the prayer was made in the first petition. This court held that even if there was an order under Section 10 of the Act prohibiting contract labor in any process or operation, there would be no automatic absorption of the contract labor by the principal employer. It was also held that it is always open to the contract labor to urge that the contract was same and nominal by raising an industrial dispute, and such dispute will have to be decided by the industrial adjudicator and not by the High Court. Thank you. Please subscribe my channel Steno Star.